Employees who are dismissed obviously have believed that they have often believed they've been hard done by. They often think that they probably haven't been hard done by, but they will give it a go. They will take legal action just to see whether the employer will buckle. And so it's very difficult actually to both get it right. Well, it's easy to get it right. It's easier to get it right, but it's very difficult actually to avoid a claim. And so what we're going to be looking at today is really how to minimise your risk of a claim against your company. Massive amounts of complicating factors. There is, in law, really two ways you can there's a number of ways you can dismiss fairly, but there's two ways you can do it, right or wrong. And a right way must follow a proper procedure. We're going to talk about, unfortunately, a little bit about the law, because what the law says, in this case the Employment Rights Act, is the only reasons you can fairly dismiss somebody. There are a number of reasons why you can fairly dismiss. Capability. Sounds easy enough. Worker isn't very good. Maybe productivity declines. Maybe off work for a long time. We're going to go through some of those reasons in a bit. But in fact, capability, in my view, I'm going to spend some time on it because in my view, it's the hardest thing to get right. Conduct. Hit the boss. Easy enough. Should be sacked, shouldn't they? Not necessarily. There are cases involving conduct where you get very surprising results when employees try it on and go to employment tribunal. I'm going to touch on redundancy because that again is another fair reason to dismiss. I hope everybody of you who works in a company has got a good HR policy on redundancy to make sure you're getting the process right. We're going to talk about the process very briefly. Unable to work because of a legal restriction, that's another ground that you can fairly dismiss. Maybe somebody who's got a work permit issue, or maybe what's the driving licence and you need to drive. And the catch-all, which is a very wide concept, but it's there in the legislation and you've got to have regard to it when you're looking for potential reasons to dismiss somebody, is some other substantial reason. And what does that mean? In itself, it's meaningless. And there's a ream of case law about what some other substantial reason could mean. I'm going to have a look at some of those, but they touch on things like regulatory issues or a lack of trust and confidence, those kind of issues. What's the legal test? When you dismiss and the case goes to law, into an employment tribunal, the tribunal will look at what you've done in context of the size of your business and the administrative resources of your business. It won't treat you like Marks & Spencer's if you're a corner shop, but if you are Marks & Spencer's, you will have to have a very, very, very good policy indeed. So the bigger the organisation, the more resources, the more critically an employment tribunal will look at what you've actually done in that particular case. They'll also look at it, and this is a concept you should have in mind as well, if you're in HR or your managers, is equity in the substantial merits of the case. What does that mean? It means that the tribunal will do what it thinks is right within the law, within the confines of the law. They will look sometimes at an employee who may have a technically quite good case, but it's obviously such a pain in the backside, they know exactly why the employer has got rid of them. And in that kind of case, an employment tribunal may well find against the employee in other circumstances for the same facts they may find for the employee. What's the test? The legal test, and again this is something to have in mind when if you are faced with dismissal issues. An employment tribunal will look at not what they would have done in the same situation. They will look at what they consider another employer of a similar size would have done. Now, they themselves may not dismiss, some employers may not dismiss, but they will look at whether dismissal is within the range of what a reasonable employer would do following an investigation. So, if you are having to go through a process, a conduct issue with an employee or capability issue with an employee, have a regard to what you believe other employers are doing in this situation, maybe other companies you work for, or examples from HR people who you know, or legal advice. Because some dismissals are going to be well outside of the range, some are going to be on the cusp and you're not quite sure. So it's very important to have regard to what you think other companies would do, and maybe write that down in any process. We're going to look at, in some detail, at capability and qualifications, because this, as I said, is, I think, the hardest thing to get right. Legal test. Does the employer honestly believe that the employee is incompetent or unsuitable? Honest. If the employer asserts that, oh yeah, this employee is rubbish, and they have no evidence to back it up, then it may well be found that's not an honest belief. So it's quite important to ensure you've got evidence if you're ever in that kind of situation. Are the grounds for that belief reasonable? In other words, test it against the evidence. With that evidence that employer has collated in a reasonable investigation, is the employer's belief in the competence of that employee reasonable? Incapacity, tricky area. You get people with short-term, ad hoc ill health, maybe a series of absence for different events. You can get employees who mysteriously seem to take the 2 weeks off each year, which just follow their annual leave, but always come home with a medical certificate. You get people with chronic ill health, maybe low-lying conditions, maybe serious one-off ill health. It is it's an extremely emotive area, and one where employers are going to tread very, very carefully. Again, it comes back to the legal test. If you feel that this employee, you just cannot keep this employee on for whatever reason, short-term or long-term, make sure that you have regard to your policies in your handbook. Very important indeed. Also look at the ACAS guidance. ACAS produce a very, very comprehensive guidance on their website, and go through a proper process. Now, where it's medical related, you have to have medical evidence. There's without a shadow of doubt, if you have a medical issue, you have got to seek medical evidence. Whether it's persistent short term, whether it's chronic long term, if you're going to go through a capability process on the grounds of health, follow a proper process, but most importantly, have medical evidence. Failure to reach a standard of the role, or employee slipping standards, or a new manager comes in who has very different ideas of how the job is meant to be done, and that accounts as a raising of standards. Is it reasonable to dismiss in this for these kind of reasons? An employer may have very good reasons, productivity-related reasons, business-related reasons, profitability-related reasons for raising standards, but the employee equally may say, oh, hang on, you're breaching my contract. I've never had to work these kind of hours. Why should I have to do so now? Is it capability? Is it bullying? Is it unreasonable behaviour by the employer? Is it recalcitrance by the employee? There's all sorts of different factors which need to be taken into account in capability issues. And again, it comes down to one very important issue, a very clear investigation with allegations against the employee, laid out very clearly what the issues are, what the standards are, and to follow a proper process and how he's going to go through that process. Intransigent or inflexible employee, well, yeah, job's worth. Now, is this capability? Somebody who does their job, clocks in at night, goes home at 5, keeps their head down, sticks to the letter of the contract, doesn't make eye contact with employees, doesn't fulfil some of the more nebulous issues maybe about workplace morale, maybe snaps occasionally at people. Clearly their heart isn't in it. Is that somebody you can dismiss? Very, very difficult area. You can, if you're in that situation, but obviously with that kind of employee, often it's so personality related, and capability does come down to issues such as attitude, health, physical health, and mental quality in the individual. These are the kind of buzzwords that fly around. Mental quality, intransigent employee, that could be somebody who, well, there's a case of a contract worker in construction who absolutely knew every best price there possibly was, always got a good deal on his supplies, everything delivered on time, very efficient. But site managers couldn't bear him, they couldn't stand working for him because they saw him as so inflexible. And the employer in the end said, well, you're great at your job, but we're going to have to sack you. The employee brought a claim for unfair dismissal, and in that case, the dismissal was held to be fair because he couldn't get it. There was something there which meant he couldn't understand what he was doing wrong and wasn't able to, or wasn't prepared to change. Same goes with a difficult employee or abrasive employee. The silent insubordination, the person who just about does it, just about on time, and maybe as they can see their boss is about to explode. What do you do in that situation? They haven't. Is it misconduct? Where is it? It comes down probably again to the kind of physical, or in this case mental quality, the ability to do the job. You can dismiss for these reasons if you are faced with a situation. But again, it comes down to the test. Do you believe that the employee is incompetent or unsuitable, and are the grounds for this belief reasonable? As long as you have that kind of test in your mind and you follow a fair process, you've got to minimise your risks. Failure to gain the expected qualifications. Typical example is accountancy, where people start maybe with and are expected to gain their qualifications on the job. They don't do it. What can you do about it in that situation? What if there's nothing in your contract of employment that says it's a precondition for you remaining here that you have this job, or that you gain these qualifications? Difficult issues, and again, it comes down to the legal test. Is this person now unsuitable for the role? If there's something in their contract, and if you're in that situation where people are required to have qualifications, make sure it's in their contract that they can, if necessarily, be dismissed fairly if they don't gain qualifications. Capability and qualifications, it must be related to what the employee is going to do. What if they're doing a particular job and then 2 years down the line they move to another job and they're just told to do it for a short time, they can't do it very well and they're sacked as a consequence? Probably, even if it's maybe a serious error, it may be that it's going to be unfair unless you've been able to vary that person's contract, and particularly unless you've given them proper training in the new role.